Welcome to Barnes Law School. Today we're going to talk about what constitutes an impeachable offense. As it has been a topic of current conversation given the impeachment of President Donald Trump, only the third impeachment in history of the United States president that has reached the United States Senate. The fourth impeachment overall. The first impeachment of a president was in 1868 of President Andrew Johnson. That was followed by the impeachment of Richard Nixon in 1972, which was then succeeded by the impeachment of Bill Clinton in 1998, and followed now the impeachment of President Donald Trump in 2019 and 2020. Of note in that context, the impeachment of President Nixon never reached the Senate, as President Nixon resigned prior to the impeachment reaching the Senate for a full trial. When, as a lawyer, what you're taught and trained when you look at impeachment or any matter of law is you go to the original source document. What does the original source document say? In this context, the original source document is the Constitution of the United States. And when we go there, what the Constitution of the United States says is an impeachable offense is one of four things. Either first, treason; second, bribery; third, a high crime; or fourth, a high misdemeanor. Of note, the definition that's used is treason, bribery, and other high crimes and misdemeanors. Each of those words is critical to understand the textual understanding of what the Constitution is saying. Basically, it's saying that treason, bribery, or crimes that are akin to treason and bribery. Hence the use of the word other high crimes and misdemeanors right after referencing treason and bribery explicitly. In addition, it says high crimes and misdemeanors. It doesn't say high crimes or misdemeanors. That deliberate choice also reflects the intention that any of an impeachable offense must be something that is akin to treason or bribery. This, in effect, imposes a threefold limitation on what can be an impeachable offense. The first is it must be something that is a crime. This imposes a threefold restriction or restraint on what can constitute an impeachable offense. The first is it must be a crime. Second, it must be a crime that is a serious crime that involves abuse of office. And third, it must be the kind of crime that cannot be resolved by the ballot box, given that the presidency is an office that is subject to elections and a limitation on tenure, namely a 4-year tenure. So when we aggregate those facts and standards, we come up with something that's very manageable, that's sufficient within the due process principles of the Constitution, and that affords an opportunity for both the President and for Congress to be on notice of what can fairly and duly constitute an impeachable offense. That it must be a crime, as defined now in our laws by the statutes of the United States, passed by the United States Congress and the President. That it must be the kind of crime that is sufficiently serious that it implicates the abuse of office, not just a private crime done for personal interest outside of and independent of public office. And third, must be the kind of crime that an election cannot resolve. This reflects the public policies and public principles that were being in discussion and in debate at the time of the convention. So, for example, at the time of the convention, there were 3 different positions held by those arguing about whether an impeachment clause should exist and what language should be in it. It would convert a constitutional republic into a parliamentary democracy of exactly the kind the Founding Fathers did not want. So a portion of those of the Constitutional Convention said there should be no impeachment power because it will inevitably and inescapably be misused and abused. We already have limitations on the presidency, limitations on his executive power and what it means by the legislative power and the judicial power being given to other branches of government outside of the discretionary control of the executive branch and the president. We already have further limitations on the president beyond just the separation of powers enumerated in the Constitution by restricting him to certain federal powers that he does not have certain powers that are reserved to the states. In addition to that, he has further restrictions on him in that he can only operate if he's elected to the presidency in the first place, subject to the public will, a limited tenure of 4 years, and subsequent amendments that we've added to the Constitution that include the capacity to remove him for incapacity under the 25th Amendment, and limitations on the scope and length of the presidency to 2 terms, passed after FDR's presidency went further than people had anticipated the president would. So there's already all these restrictions and restraints and limits and constraints on the power of the presidency. There is no need to have an additional impeachment power in Congress. That was the argument of many of the Founding Fathers. Some of those arguments would be further institutionalized by subsequent amendments to the Constitution, like the 25th Amendment, like the amendment that limits him to 2 terms. But other of those limitations were already there. The 4-year tenure requirement, the popular election requirement, the separation of powers requirements. So that portion of the Founding Fathers said, we don't need an impeachment clause. It will be abused. Just look at what's happening in the British parliamentary system. In fact, there was a controversial impeachment taking place right at the time the Founding Fathers were debating the Constitution at the Constitutional Convention. On top of that, and in addition to that, there were separate groups, 2 other groups at the Founding Fathers, who had different opinions on impeachment. The second group said, we're worried about a president selling out the country to a foreign royalty in such a way that cannot be remedied by an election. It's important to understand the context of the Constitutional Convention back then. Back then, a constitutional republic was a novelty. Back then, a democracy was something that hadn't been heard of in hundreds and hundreds of years. Most of the people in the United States had no familiarity with a functioning democracy. Most were part of monarchies and royal rule. So their concern was that after the successful revolution, the Declaration of Independence, the United States Constitution should reflect the principles behind that revolution and the Declaration of Independence, and should make sure that whatever happens, their new fragile government would not be undermined by executive officials like the president and others selling out to foreign royalty, doing things like selling parts of the country to foreign royalty, doing things like selling out the whole country and in exchange for becoming the Duke of Normandy or the Duke of Marseille or something of that nature. That was their animating concern. That was the backdrop of which the debate over impeachment took place. So this second group had that at its centerpiece. Its concern was whether the president could use the powers of the presidency to make elections moot and effectively destroy the country before it could even begin. The third group was a group that said, well, we recognize this concern of both the first and second group, and we recommend a compromise. Let's include an impeachment clause. Let's include an impeachment power to Congress, but let's set it up so it has a lot of protections in it, that the language of it will be quasi-criminal in character, so that the rights of confrontation, the rights of counsel, the rights of due process would all apply to the president or the individual being impeached. Secondly, there'll be limitations on what offenses can be the basis of impeachment. We're going to limit it to treason. We're going to limit it to bribery. We're going to limit it to light crimes. And on top of that, we'll have additional protections by requiring that only one branch be involved in the investigative quasi-indictment stage of the case, that being the House, and the Senate being involved in the trial. So 2 different branches of Congress being involved at different levels. Only the House can initiate. Only the Senate can try. And on top of that, we're going to require a super 2/3 majority for any conviction and removal to occur in the Senate. And that these combinations of these procedural protections and choosing the people's elected representatives as both the indicters and the triers will help provide additional layers of protection against the possible misuse and abuse of impeachment power, as was recurrent in the British system and was complained about and was a concern of the Founding Fathers. So the third group ultimately won out. The first group wanted no impeachment clause. The second group said, look, there's a lot of abuses of power. We want a maladministration. We want an abuse of power kind of provision. And the third group said, no, we don't need something as broad and generic as an abuse of power provision. As Madison put it, that would just be subjecting the president to service at the pleasure of the Senate. We don't need something that generic, that vague, aside from the due process issues it would implicate. But we do need something more than what the first group is providing. So that's why they said we'll do treason. That's impeachable. We'll do bribery. That's impeachable. And when the second group objected and said, well, there's a lot of things that could happen that would endanger the young republic that maybe don't fit the precise legal contours of treason or bribery. To give just one illustration, our treason statutes require we be at war with a particular country generally for any of the treason statutes to apply. They said we need to be able to have a catch-all protective phrase for something that's like treason and bribery, but might not meet the literal definitions. And so that's why the Founding Fathers said, okay, we'll add other high crimes and misdemeanors against the United States as our provision. During the editing process, the editors thought the words against the United States were repetitive and duplicative and cumulative because they thought it so self-apparent that high crimes and misdemeanors were things analogous to treason and bribery, given the verbiage used, other high crimes and misdemeanors, that meant that there was no need to have the words against the United States as mere surplusage. And that's the only reason why it was ultimately removed from the plain text of the Constitution.